Another day, another story with your friendly AI lawyer. Facts. The case involves the constitutionality of the Plunder Law, which defines and penalizes the crime of plunder. The petitioner, Joseph Ejercito Estrada, argues that the law is defectively fashioned and violates the fundamental rights of the accused to due process and to be informed of the nature and cause of the accusation against him. Specifically, he claims that the law suffers from the vice of vagueness, dispenses with the reasonable doubt standard in criminal prosecutions, and abolishes the element of mens rea in crimes already punishable under the revised penal code. The provisions of the Plunder Law that are claimed to have transgressed constitutional boundaries are sections 1, par. D, 2 and 4. Issues. The issues for resolution in the instant petition for certiorari are whether the Plunder Law is unconstitutional for being vague, requires less evidence for proving the predicate crimes of plunder and therefore violates the rights of the accused to due process, and whether plunder as defined in RA 7080 is a malum prohibitum, and if so, whether it is within the power of Congress to so classify it. Ruling. The court must determine whether the Plunder Law contains ascertainable standards and well-defined parameters that would enable the accused to determine the nature of his violation. The court must also determine whether the law clearly and palpably transgresses the hallowed domain of the organic law. The petitioner has failed to demonstrate beyond any tinge of doubt that there is indeed an infringement of the Constitution, and therefore, the court upholds the constitutionality of the Plunder Law. Discussion on legal doctrines applied. The Plunder Law is not unconstitutional for being impermissibly vague and overbroad and does not deny the petitioner the right to be informed of the nature and cause of the accusation against him, hence, violative of his fundamental right to due process. The words combination and series in the key phrase, a combination or series of overt or criminal acts, found in Sec. 1, par. D, and Sec. 2. And the word pattern in Sec. 4 are not vague or ambiguous. The legislature did not intend a technical or distinctive meaning for combination and series. The term pattern is sufficiently defined in Sec. 4 in relation to Sec. 1, par. D, and Sec. 2. The law gives a fair warning and sufficient notice of what it seeks to penalize. The void for vagueness doctrine can only be invoked against legislation that is utterly vague on its face, i.e., that which cannot be clarified either by a saving clause or by construction. The use of the reasonable doubt standard is indispensable to command the respect and confidence of the community in the application of criminal law. The Plunder Law is not unconstitutional and that the use of the reasonable doubt standard is critical to protect the accused against conviction except upon proof beyond reasonable doubt of every fact necessary to constitute the crime with which he is charged. The court held that the prosecution only needs to prove a pattern of overt or criminal acts indicative of the overall unlawful scheme or conspiracy, which arises where the prosecution is able to prove beyond reasonable doubt the predicate acts as defined in Section 1, paragraph D. The court also held that mens rea is an element of plunder, as evidenced by the application of mitigating and extenuating circumstances in the revised Penal Code to prosecutions under the Anti-Plunder Law. The court further held that Section 4 is a purely procedural measure that does not define or establish any substantive right in favor of the accused but only operates in furtherance of a remedy. Even without invoking Section 4, a conviction for plunder may be had, as long as the prosecution presents sufficient evidence to prove the guilt of the accused beyond reasonable doubt. The court found that the law failed to provide a clear definition of the terms combination and series, which are crucial elements of the crime of plunder. The court also found that the penalty for plunder, which could result in the death penalty for acts that would ordinarily result in the imposition of correctional penalties only, was blatantly disproportionate to the offense and violated due process and the constitutional guarantees against cruel or inhuman punishment. Thanks for watching. Please subscribe to my channel.